Thanks, Susie, and thanks everyone for having me. I'm gonna just try and share my screen and make sure the PowerPoint works. So Susie, I'll rely on you to tell me if that's
cool.
In fact what I am doing.
Looking good.
Okay. Do we see it in the presenter view or in the slideshow view?
Presenter view.
Okay. How about now?
Slideshow view.
Great. So this is the view you should be seeing, right? The full screen. Okay, great. All right. Well, hi everyone. As Susie mentioned, my name is Trisha Pande, and I'm here with James Whalen. And to just quickly introduce myself, I'm an attorney at Patterson Harkavy. It's a civil rights and labor law firm based out of Chapel Hill, though we have colleagues in Greensboro and Raleigh as well. And our firm has deep roots in the labor movement here in North Carolina. I'm sure some of you are familiar with the Norma Rae movie. Our firm was part of working on that J.P. Stevens campaign way back when, so we've been around for a while. And as Susie mentioned, a lot of my work over the last few years has involved faculty and grad student organizing efforts. And in the last 2 years, a lot of time spent with Elon. So I'm glad to be with everyone here today and really proud to be supporting the faculty at Elon. And I'll let James introduce himself.
Hi everyone, I'm James. I'm a law student at UNC and a summer intern and really enjoying it. We have to work from home, of course, as I'm sure you all have to too. So that part hasn't been as fun, but the internship is going really well. I wanted to also mention that my very first job out of college, I was a janitor at Elon. So I have some solidarity with you guys. In fact, I'm wearing my janitor shirt today. It is very comfortable. So I'm looking forward to being a part of this team and presenting part of the presentation.
Thanks, James. We're very lucky to have James with us for the summer and to be working with us on this presentation. Okay, so first, let's go through the agenda really quickly. I'm going to use the acronym UI to refer to unemployment insurance. So first, we're going to talk about the process overview, generally what UI is, how does it kind of work, what's the legal framework for it, and then we'll dive into the eligibility of faculty for unemployment insurance. We'll cover very briefly the impact of COVID, as I know that's on everyone's minds, and then I'll take you through the application process, and then we'll do questions. Real quickly before we get into things, I want to just make sure that everybody understands this is not to be taken as legal advice. This is general information about unemployment, but if you have specific questions about your situation or you want legal advice that's tailored to you and protected by attorney-client privilege, I encourage you to reach out to a lawyer. And as Susie mentioned, I'll leave my contact information at the end of this presentation so that you can feel free to reach out to me as well with your specific unemployment questions, or for that matter, any other follow-up questions you have from this presentation. Okay. So what is unemployment insurance? It was created in 1935 as part of the Social Security Act, born out of New Deal legislation and following the Great Depression. The sort of legal framework and tax framework for it was developed through the Federal Unemployment Tax Act of 1939, which has since been amended a few times. Interestingly, the unemployment insurance program is a joint federal and state program. So what that means is every state has its own program, but all of those programs are required to follow federal law. So there's sort of a shell of federal law within which all of the state programs operate and develop their own standards and amounts, and the amounts of unemployment insurance can vary pretty widely between the states. The purpose of unemployment insurance is to provide partial income replacement for workers who are involuntarily unemployed. So that means folks who are unemployed through no fault of their own. So that can be refusal to work, or oftentimes employers argue that former employees are ineligible for unemployment because they were terminated for good cause, violating a work rule, or accumulating too many points in a point system, something like that. But if you're terminated because there's simply no work available, that would be considered unemployment through no fault of your own. There are also some exceptions when you can refuse to work on the basis of good cause, and those are pretty narrow circumstances, but we'll talk a little bit about that later. So that's sort of what the purpose of the unemployment insurance program is. And it's also supposed to, provide some mitigation when there are really high rates of unemployment like we're experiencing right now, for states as well as individuals, so that, people are still able to pay their rent or buy groceries or things like that, and sort of protect the states from a shock brought by high unemployment rates. Up until the 70s, the unemployment insurance program only covered private employers, but in the 70s it was extended to cover public sector employers and most nonprofits, so that includes higher education institutions. And the unemployment insurance programs are funded by taxes that are paid by employers. So employers pay a quarterly unemployment tax that is tied to their experience with unemployment. So basically, the more layoffs you have, the higher your unemployment tax will be. And I think this is an important point to mention, because it sort of explains why employers may be more inclined to contest unemployment claims, because it affects their taxes. Some states allow public sector employers to do a direct dollar-for-dollar reimbursement of unemployment that's paid out to former employees. That's a more cost-effective approach. My understanding is in North Carolina, higher education institutions have to pay a quarterly unemployment tax. Okay, so looking generally at North Carolina, there are some basic eligibility requirements to receive unemployment insurance in the state. The first, as we just discussed, is to be unemployed through no fault of your own. Claimants have to have earned sufficient wages to establish a claim. So there's sort of a baseline requirement that a claimant be monetarily eligible. And generally this is a fairly low bar, but it will depend on your work history and how much you earned during your work history. If you want specific information about that, we can discuss that later, but just for the purposes of time, I won't get too technically into that. The claimant has to be able, available, and actively seeking work. And there's a weekly certification that you have to fill out to remain eligible for benefits, sort of stating that you are actively seeking work. And the last requirement is that you not be disqualified. And there are a few ways in which employees can be disqualified for unemployment insurance. For example, employees without work authorization or documentation may be ineligible. There are other bases for a disqualification, some of which we'll cover a little later. I want to just mention, before going into sort of more the specifics of how unemployment insurance affects educational employees, I wanted to just point out that in 2013, our General Assembly passed some very deep cuts to unemployment benefits. To give you a sense, they lowered the maximum benefit rate from $535 a week to $350 a week, and the maximum duration of receiving benefits from 26 weeks to now 12 weeks, although that number can go up to 20 weeks depending on the state's unemployment rate. So it was a pretty steep cut to benefits. We now have among the lowest benefits in the country. And North Carolina is also often cited as having one of the lowest, if not the lowest, recipiency rate. In 2019, we had a recipiency rate of 9.1%. among claimants for unemployment. And we also have one of the highest exhaustion rates. So that's the rate at which individual claimants run out of unemployment insurance. And so because we have such a short period of time for receiving benefits of 12 weeks, about 47.1% of claimants exhaust their benefits. So now that we've sort of covered the basics, we're going to talk a little bit about the eligibility of non-tenure track faculty for unemployment. First, I want to just take a look at the state law and sort of frame it through that. So North Carolina general statutes, and I put this cite in there, basically says that benefits won't be paid to non-tenure track faculty or to faculty to the maximum extent allowed by federal law. So section 3304 of the code, that's referring to the federal code of regulations. So we need to take a look at what the federal law says. So as I mentioned, just to give you a little background on how federal law has approached faculty eligibility for unemployment compensation. In the 1970s, the Federal Unemployment Tax Act was amended to extend coverage to employees at higher ed institutions. The amendments also excluded higher ed employees who had a contract or reasonable assurance of reemployment the following year. The exact language in the code is below, but just for your own purposes, I wanted to sort of mention that when these amendments were made, the Senate Finance Committee report suggested that this exemption for faculty was based on this understanding that employment in higher education institutions was relatively stable and not subject to the same degree of fluctuation as in other industries. And the Senate report also sort of noted how a lot of contracts were premised on the idea that faculty work, 9 months out of the year, but that they have these breaks in between terms, and that, the compensation they receive is meant to cover those breaks. Clearly higher education has changed a lot since the 1970s. And so this law was sort of written with a very different understanding of how higher education works and sort of the availability of tenure track positions. Following sort of these amendments, there were a few attempts to sort of interpret it. First was in 1987, the Department of Labor, the US Department of Labor issued some guidance on what it meant for higher education employees to have a reasonable assurance of reemployment in the following term. And what happened was, following that guidance, a bunch of states started interpreting it differently. So after a lot of work in 2016, the DOL issued new guidance on what reasonable assurance meant and when faculty could be denied unemployment. And that guidance is what we're going to talk about today. And I should note that getting some clarity around that issue was really the result of a lot of work from various labor organizations and activist organizations like AAUP and SEIU. So, there was a long sort of road leading up to this. And now I'll hand it over to James to talk about that federal guidance and when faculty can be denied unemployment insurance.
So again, I'm James. The next few slides are going to go in more detail over the following 4 bullet points. But the basic idea here, as mentioned in the previous slide, is that if you are between semesters or between work as a faculty member, the understanding is that you're not unemployed, you're on a break. Now we know that isn't necessarily true anymore, but that's the understanding in the law. And so the major question here is whether or not you are between employment or you are becoming unemployed without any kind of lead on the next semester. So really this all hinges on the offer you've received, and there are 4 elements to an offer that is sufficient. And they're listed here. The first 3 are very self-explanatory, and they're broad, And so in most cases, I'd say they probably aren't going to be the key, and that's why the fourth one is what we discuss for the next few slides, but they're important, so I'll go through them. First of all, you do, of course, need some kind of actual offer, a genuine offer where the university does intend on hiring you back, and it needs to be an offer that's made by someone who has the authority to make that offer, like the dean or the president, or someone else who has the authority to hire faculty. Now, an offer does not have to be a written contract. And as it says there, an offer can be written, it can be oral, and in some cases it can just be implied. In the guidance, in one of the examples, a faculty member who's been there a long, long time just sees that their course that they teach is listed on the course catalog with their name associated, and that was an implied offer that they would stick around. So it's very fact dependent, but in general, it's a very broad requirement that as long as you have some kind of offer, that first condition is met. The second condition is also very broad, and very simply, it says there in the same capacity, but it very simply means that if you're a professional, the offer has to be for a professional job. So if you're a professor, then the offer has to be for a teaching job. It does not have to be the same department. It does not have to be the same classes. If Elon's mathematics department starts to run low and they offer a history teacher the job of teaching introductory calculus, that may still satisfy that second element. So really what we're talking about here is staying in a professional job. The third one may come into play for some of you all coming into the fall semester, and that's that the economic conditions, the pay, has to not be considerably less. It has to be largely the same as it was. Now, considerably less is a little different state by state. The federal guidance is 90%. So as long as you are making 90% or more, or the offer is for 90% or more of what you were making before, then under the federal guidance, that would be an offer that is sufficient. If the offer is for less than that, then it would be insufficient. That guidance is not the same across, I mean, it's the federal guidance, but that's not necessarily going to be the case. It's going to be dependent on a lot of other factors. But the key is whether or not it's considerably less. In general, hopefully, you won't get a pay cut that's going to be that dramatic teaching the same number of courses. Where this will probably come up for a lot of folks, and where it's come up in the past, is where in previous years you've taught 4 courses, and then you are dropped down to 3 or 2 courses, in which case the total amount that you would be paid would drop considerably. So if that's the case, then even though you may be offered a job back to teach, if you're not offered a job back to teach the same number of courses, this may come into effect. So that's something to watch out for. If you're not receiving a similar pay scale, then that may be something you want to look at. Those are the first 3, and again, they're fairly broad and they're fairly straightforward. The fourth one is the most complicated one. And the basic idea there is that if you have an offer that's for the same capacity, it's a teaching offer, and it's in the same range of pay, then the question becomes, is it highly probable that you will get that job back? And it can be highly probable because it's a firm contract, or because you have this thing called reasonable assurance, which we'll get to on a subsequent slide. But the first one is a contract, and this one is an easier one to understand. As a reminder from the previous slide, an offer does not have to be a contract. An offer can be a written offer, it can be in contract form, it can be an email, it can be oral, it can be implied. But if you do have a contract and it's a lock solid contract, then you probably do not qualify and you probably cannot receive unemployment insurance. But what does it mean to have a lock solid contract? Again, there are 3 pieces to that. First of all, it has to be enforceable. That's an obvious one. It has to be enforceable under state law, and there's a whole course in law school that you take to decide whether or not it's an enforceable contract. The second thing, and this is going to probably be the most important element for you guys to know, for this slide, as far as a contract goes, it cannot be contingent. So if your contract says, we will hire you back to teach English 101 if enough students sign up for English 101, that is a contingent contract, and that would not satisfy this step, and we would have to move to the next. Finally, the compensation under this contract has to be for the entire year or listed as an annual basis. It can't be just a semester contract. So if you receive just a semester contract, again, we would go to the next step. So in general, we're going to look at the reasonable assurance standard rather than this standard. But in certain cases, your contract may be lock solid, in which case you would not qualify for unemployment insurance based on this alone. But for most people, it's going to be the reasonable assurance standard. And being a law student, I can tell you, reasonable is the word of the day pretty much every day in law school. It's a very flexible issue, and as it says there in the third bullet point, what we're looking at here is the totality of the circumstances. You can look at everything together, you added it up, you balance, and you can come out on one side or the other as to whether or not a person has a reasonable expectation that their job will be there. In order to assess this, we look at everything, but one of the things we focus on is the contingencies that are present in the contract. Remember, if there are no contingencies and you have a written contract, then you do not qualify for unemployment insurance. That was the previous slide. If there are contingencies, then we have to try to figure out if those contingencies are highly probable to be met. And we break this down into two categories. Some contingencies are things that are within the university's control, and we'll look at some more examples of this in a second. But if the contingent factors are within the employer's control, that's going to be a strong indication that you do not have reasonable insurance. In other words, you would be eligible for unemployment insurance. On the other hand, if the contingencies are not within the employer's control, then we have to just look factually to see if that's probably going to be met or not going to be met. And again, we look at all of the factors, we add them together, and we try to balance. And at the end of the day, that's going to be left up to the state Department of Labor to try to figure out if that's going to be met. On the appeals process, you may be able to argue that later, but when we get to your questions, a lot of our answers may be, it depends, because this is going to be a flexible test. And again, we've broken down some of these contingent factors. So if the contingent factor is within the control of the employer, that's going to be a strong indication that you do not expect to get your job back. And that's pretty obvious. Look at that last bullet point on, it's my left, I assume it's everybody's left side, that we reserve the right to retract this offer, ... Oftentimes, contracts in a wide range of jobs will say something like that. If you have a job offer, but it says we can revoke this offer, then that's not really a genuine offer. That just is notice that we might hire you, but we haven't decided yet. That's the most obvious example of that, but there are others. For example, you will teach this course if we decide to offer this course. Course programming and final course offerings, those are within the employer's control. Also, allocation of the funding. For example, if we decide to spend this much money on the English department, then you will get your job back. That is a contingent factor based on the employer's control, which means that you probably do qualify for unemployment insurance because that's probably not reasonable insurance. The other side of that are things that are outside the employer's control. Enrollment is a perfect example, and I know that's something a lot of universities are worried about right now with COVID-19, is whether or not their enrollment numbers will be the same. That's both enrollment for the entire university and enrollment for individual courses, assuming the course is elective. Total funding, the state universities, of course, the state funding would be outside their control. Any kind of grants, any kind of federal funding, and then sometimes offers will be contingent on seniority of eligible employees. Who is the most senior employee is not within the employer's control. So things like that are outside the employer's control, that doesn't necessarily mean that you won't qualify, but if that's the case, we have to ask whether or not that is likely to be met. And we have some examples on the next slide to talk about how we evaluate whether or not something is highly probable. So now I'm going to do something that everybody hates, and I'm going to read directly from the PowerPoint. So you can read along with me, but it's important to get the details right. So I'd like to read it, and then we'll walk through these. I'll walk through the first example, and Trisha will walk through the second one. So example one, a part-time faculty member, and I'm going to call the part-time faculty member Meg, because that's my mom, and for a long time she was a part-time faculty member. So Meg has taught 3 classes of English 101, which is a required class for incoming freshmen, has taught 3 classes of English 101 for 10 consecutive semesters. At the end of the spring semester, she receives a written offer from her department chair to teach 3 English 101 classes in the fall semester, contingent on enrollment. There's no change in the compensation. There's no information indicating that enrollment will decline. So, first question, under these facts, is she eligible for unemployment insurance? Under these facts, probably not. And the reasons are all in the previous slides. So first of all, she does have an offer. As far as we can tell, it's a genuine offer, and it's from her department chair. So it's from someone who does have the authority to extend that offer. It's a written offer. It didn't have to be a written offer, but it is a written offer. And the written offer is in the same capacity because she's a teacher. It's a professional job. It doesn't have to be in the same department, but this happens to be in the same department. And it sounds like the compensation will be the same. First of all, the rate will be the same, but also she's teaching the same number of courses. So she probably will receive a very similar compensation across the semesters, which means that those first 3 elements are met. So now we have to ask whether or not that she has the reasonable assurance. First of all, she has a written offer, but the offer is conditioned on enrollment, which means it is not a locked solid contract. So we have to move to step 2 and ask whether or not there's reasonable assurance. In this case, there probably is reasonable assurance. She's got a contingent on enrollment, but the enrollment in this case looks pretty consistent. It's a required course, so there's not much of a question as to whether or not enough students will sign up. They have to. And she's been teaching 3 courses of this every semester for 10 consecutive semesters. So all of the indicators point to the fact that she probably will teach all 3 of these again. And that means she probably is between jobs rather than ending a job with no hope of getting a new one. So she probably cannot get unemployment insurance under these facts. The second question there is, what if she refuses the offer? And that goes all the way back to the beginning slides. If you refuse the offer, then you are not unemployed involuntarily. She is volunteering to be unemployed, in which case she would not qualify for unemployment insurance. There's a caveat there that in some cases, if you have good cause, if you have a really good reason for refusing an offer, then you may be eligible, but that's a very narrow exception, and that's not something we're going to go into detail for here. So in general, if she refuses the offer, then she would not be eligible for unemployment insurance. The last thing is more complicated, and I'll read it. Would she be eligible if the course was elective and contingent on department budget? So there, contingent on department budget, that is a employer-controlled contingency. The employer gets to decide how much each department gets as part of the budget. So the language we use is that would be a primary consideration. That is something that is very weighty in the analysis. The fact that it's contingent strongly indicates that this person would not have reasonable insurance. Still, we have to look at all of the factors, and the rest of the factors lean on the other direction. It's still something she's taught every semester for 10 semesters. It has consistent enrollment in the past. The enrollment for the whole school is expected to stay the same. So the state may still find that that she has reasonable assurance. It's highly probable that her job will still be there. On the other hand, the court could go the other way. The state agency could go out the other way. So this one would be a tough one. She has a stronger case here, but it would very much depend on other details and the way the state agency evaluates this.
Great, thanks, James. So I'll cover example 2. So in example 2, Meg taught 1 course of English 101 at College A, 2 courses of Advanced Political Science at College B, and 1 course of Renaissance Lit at College C. All 3 colleges have made offers of employment to Meg to teach again in the spring semester, and each offers the same per course rate of pay, but College B is only offering Meg 1 course, not 2. All of the offers are contingent on enrollment. At College A, English 101 is a required course, and College A has recently increased enrollment. No additional information is available on enrollment in advanced political science courses at College B. College C has an innovative program on Renaissance studies, which is increasingly attracting students to the college. However, the college has only taught Renaissance Lit in the spring semester, 3 out of the 5 most recent spring semesters due to lack of enrollment. How does the between and within term denial apply to this claim? So is Meg eligible for unemployment compensation given all of these facts? So the way that a state agency would look at this is they would see if there is reasonable assurance or a contract at each of the colleges. So going through all of the requirements that James just discussed. So if we look at College A, you look at the enrollment contingency, that's not within the employer's control. But if you consider the totality of the circumstances, it seems likely or highly probable that a job will be available to Meg in the fall because course enrollment is increasing and the course is required. And even with giving primary weight to the contingency, it still seems highly probable that Meg will be able to teach those courses. So it looks like she has reasonable assurance for College A. So denial of claims there. Then you go to College B. Now in College B, it looks like she was offered 1 course and not 2. So that, going back to the initial 3 requirements that James talked about before you get to the reasonable assurance analysis, 1, there was an offer. 2, it's in the same capacity, but 3, the economic circumstances are significantly different. She's now teaching half the course load that she was previously teaching. So for that reason, we're going to knock that one out. She could be eligible for unemployment there because her offer is significantly different. So we don't need to get to the reasonable assurance or contract test. Then we go to College C. The enrollment contingency is not within the employer's control, but looking at the totality of the circumstances, it looks like it may not be highly probable that Meg will get to teach that class, right? It's only been offered 3 of the last 5 semesters, and while there's some interest, drumming up among the students, the employment has been spotty in the past, and so it seems probable that there's not reasonable assurance. So there's reasonable assurance at College A, and at College B and C, it looks like she may have a claim for unemployment benefits. So, what happens when you have a reasonable assurance of rehirement and are not eligible for unemployment compensation with respect to one of your teaching jobs at a university, but you lack reasonable assurance at another? So there are sort of 2 options that come into play here. The state can first decide that because you have reasonable assurance from one college but not from the other 2, unemployment compensation is payable based on the services that you provide at the 2 schools where you don't have reasonable insurance. So they'll look at sort of what you're earning at those schools and base your unemployment off of that. Option B is because there's only reasonable assurance from one of the schools that make up 25% of your wages from the previous term, the economic conditions as a whole are considerably less, and they'll pay you unemployment compensation based on sort of the whole picture. But the employer, College A, that's offering you reasonable assurance won't have to pay the tax associated with unemployment compensation. So either they look at the 2, College B and C, where you're not, where you lack reasonable assurance and are able to get unemployment compensation, and they just look at those 2 and kind of like don't look at College A, or they look at the holistic economic picture and see, how your income is suffering based on, the allocation of classes among the 3 colleges. So let's, if you were getting only a quarter of your income from the teaching at College A, that may play into that analysis. And it's in the state's discretion which option it decides to go with, but the state has to be consistent in exercising that option. So that's sort of a convoluted one, but I wanted to sort of offer a more complicated one. And I know that a lot of folks teach at multiple institutions. So thought it might be useful to walk through that one. Okay, now I'm going to quickly, I know I want to keep on time. I can't see my chat function because I'm sharing my screen, but I'm sure Jake is telling me that my time. So the application process, very quickly. The quickest and most efficient way to file your claim is online through the website. You basically set up an online account, you have an individual PIN number, and you apply online. Or you can call by phone, especially now in light of the rising unemployment claims. I strongly suggest that you apply online during non-business hours. To file your claim, you'll need a couple of things. Those are listed for you on the PowerPoint. Your social security number, information about your most recent employment and pay, your work history for the last 2 years, and your banking information if you're going to receive your payment by direct deposit. So that's just some of the information that you might need. To maintain your eligibility, even while your claim is pending, you need to fill out your weekly certification with DES to show that you're still able to work, that you're still not at work. And as we've sort of been walking through these examples and through these tests, it's important to remember you can have reasonable assurance one week and not the next, or you cannot have reasonable assurance and then suddenly get a contract, or have that contract withdrawn for whatever reason, if it's contingent on enrollment. So it's important to keep your weekly certification, and it's also important to keep track of whether or not you think you still have reasonable assurance. I'll talk a little bit at the end about COVID, but if you're filing because you lost your job for a directly related COVID reason, then you can answer yes to the question, are you looking for work? But that does not necessarily apply to everybody. Just sort of flagging that for you. And if you need to follow up with me later on, feel free to do so. So after you file, the employer has 10 days to respond to your claim. Like I said in the beginning, this is funded by a tax that's levied on employers. So there is some incentive for employers to dispute a claim if they think it doesn't have merit. And so, they have 10 days to respond to it. If they dispute it, then you may be contacted for an interview or asked to respond to that. Sometimes you're not, and it's, either outright denied or granted. If you're denied benefits, you can appeal that, and very specific instructions will be included on your determination. You should file online again as the most efficient way. And once your appeal is filed, DES will schedule your hearing before an appeals referee. And if I didn't say so before, the DES is the Division of Employment Security, and that's within the North Carolina Department of Commerce, interestingly enough. So an appeals referee can hold a hearing by person or in person or by phone. In my experience, I think every hearing I've done has been by phone. If you're having the hearing by phone, you have to provide copies of your evidence to the appeals referee beforehand, and any information about witnesses that you want to have call in to testify on your behalf. Some people choose to have legal representation during these hearings. It's not required. So you can certainly represent yourself if you feel comfortable doing so, though some people do look for legal representation. If your appeal is denied by the appeals referee, then you can appeal again to the North Carolina Board of Review within 10 days of the date that the appeals referee decision is mailed to you. The Board of Review is 3 people. They're appointed, and they take a look at the evidence and render a decision. And if they again deny your claim, then you can petition for judicial review. So we're getting pretty far ahead. You can appeal and appeal and appeal until you get to the courts. But for now, I think the most important and most common step is to appeal to an appeals referee. So I wanted to focus on that. Okay, I don't want to run out of time, but just briefly touch on COVID. So there have been federal and state legislative responses to COVID. I'm going to kind of ignore the state responses for now because I think we'll focus on the most important ones. The Federal CARES Act provided for 3 federally funded unemployment insurance programs. This little nifty graphic on the left is from the DES website. I will say that the DES website is very informative and helpful. So I would take a look at it if you have questions. There's quite a bit of information on there. So among the 3 programs, I want to highlight 2. So pandemic unemployment compensation is basically an additional $600 a week for anyone who's receiving unemployment insurance, whether it's state or whether it's federal. And that program runs through July 31st. Then you have pandemic emergency unemployment compensation. That's a 13-week extension of the state unemployment insurance benefits. So once you've used up your 12 weeks, you can file and get a 13-week extension. Note that this is not an automatic thing that kicks in like the PUC. The PEUC, you have to file for that additional 13 weeks, and you can do that online. And just notably, you know, because we have such a short duration of unemployment benefits, North Carolina is receiving a lot less from this extension than other states. If you have 26 weeks and then an additional 13 weeks, you know, that's much better than 12 weeks plus 13 weeks. So we're sort of unable to take advantage, I think, of some of the federally funded unemployment insurance programs. The last I'll briefly touch on is pandemic unemployment assistance. That's probably one you've heard about in the news that provides unemployment insurance for workers who are otherwise ineligible under state law. So that could include independent contractors. A lot of news has been reporting about gig economy workers being eligible through PUA. That provides up to 39 weeks of benefits, a max of $350 a week, and the program expires December 31st. But notably, the PUA claims have to be COVID related. So, you know, for example, if you're having symptoms or you're taking care of someone in your household who has COVID, or you were scheduled to start a job, but then the offer was withdrawn because of COVID. Things like that. It's not just like PUC where anyone, no matter whether you're getting unemployment insurance for COVID related reasons or not, gets the $600. PUA is for specific unemployment that's related to COVID. And there are a list of sort of the qualifying reasons on the DES website. And also on our website. So you can see, you can go to this link here, the COVID-19 resources, if you want more information. And then below that is my contact information. And like I said, I am accepting any call about unemployment compensation during the COVID pandemic and shutdown. And so you should feel free to follow up with me at that number. You can also reach me through the organizing committee that helped put together this webinar. And the last thing I'll say is, you know, about COVID is that when you're looking at your reasonable assurance factors, you know, that can also be a factor. COVID is really an unprecedented situation. It's affected higher education institutions just as it has every other employer. And so, you know, to the extent that you're thinking about, you know, what evidence you want to support your claim, you know, that is all relevant. So I will leave it at that and stop sharing my screen somehow, and we will turn to questions.